Good morning, everyone. It's me again. Welcome back to your channel, the channel where we discuss everything law. This week, we're going to be talking about something entirely different. Have you received a Section 21 notice or a Section 8 notice from a landlord? Are you panicking? Are you worried? What can I do? Anyway, in this video, we're going to be telling you everything you need to know about Section 21 notice. We'll tell you everything you need to know about Section 8 notice. We'll tell you what the difference between the two are. And after that, we'll give you an update on what's happening with the eviction proceedings here in London or in the whole of England later this year. Section 21 notice is that notice you receive from your landlord when you've done absolutely nothing. So it means to no fault of yours, you can be evicted. Yes, that's the law in England and Wales. I know a lot of people will make, will cry about this, but again, like I said earlier, there is a bill before Parliament, that is addressing this injustice. But for now, until that is done, you need to watch this. I need to tell you what you need to do when you receive this no fault eviction notice. Yes, no fault. To no fault of yours, you've been asked to leave. The landlord needs his property back. Maybe he wants to give it to his second wife, or maybe his child is now grown. He wants them to move in there. It could be any reason why the landlord wants the property back, and you've done absolutely nothing. So it's not fair. I get that. But this needs to happen. So when you receive one, what should you do? My first advice would be for you to talk to a solicitor. But again, not everybody, will be able to speak to a solicitor. So for whatever reason, if you're not able to speak to a solicitor, then you might want to watch this video. The first thing you should look out for when you receive a Section 21 notice is how long have you been on the property? Ask yourself that question. Have I been here for less than 4 months? If that's the case, then you've got absolutely nothing to worry about. If I were you, I get on my bed, get on that duvet, sleep off as if nothing happened. But again, that's if you've been less than 4 months on the property, because the law says the landlord cannot serve you a Section 21 notice within the first 4 months of your tenancy. The whole idea is for you to enjoy at least quiet possession of your property, at least for a while. So the minimum is 4 months. After that, the landlord can give notice, which means by the end of 6 months, you're expected to leave, which is fair. Having said that, that's just the first thing you have to look out for. The second thing you have to look out for, if you remember, in 2019, there was so much cry about tenant charging this, renewal fee, that fee, this fee, and tenant were paying a lot of fees for so many things that we just couldn't understand. So the law came in 2019 and it canceled all of these fees. So if you've paid any fee to your tenant, to your estate agent, to your landlord, before 2019, the law requires that they return those fees back to you. So if you are anybody who has not received those refunds, from your landlord or your estate agent since the law came into being in 2019, and you receive a Section 21 notice, trust me, you have absolutely nothing to worry about, because the law says that your landlord cannot serve a valid Section 21 notice when you are being owed prescribed fees. Those fees are prescribed, they are illegal. So if they've charged it, they've not returned it back to you, then you've got absolutely nothing to worry about. The last one you need to look out for, as far as these issues are concerned, is to ask yourself, have I asked my landlord to come repair something on my property in the last 6 months? Or has it even escalated to the point where the local authority has issued an improvement notice to your landlord to come carry out repairs on your property? If that has happened within the last 6 months, then your landlord can serve a valid Section 21 notice after 6 months of the repairs, and all of that. But if it's within that 6 months of the repairs being carried out, your landlord can't do nothing. So it means if I issue a notice today to my landlord to carry out repairs, and he decides, you have to leave by next month, even though he's carried out the repairs, then that's unlawful. It's called revenge eviction. The law would deem it that he's evicting me because I've had this habit of always asking for repairs. So that's how the law sees it, revenge eviction, and that is discouraged here in England and Wales. So landlord cannot serve a Section 21 notice in those three instances. By way of summary, what I've said is three things you look at: 4 months on the property, you pay prescribed fee has not been returned back to you, or you've asked your landlord to repair or to carry out repairs on your property, or the local authority had request on your behalf for your landlord to carry out repairs. And these things, this repair had happened less than 6 months ago, it cannot serve a valid Section 21 notice. So if you have this information, you receive one, and it doesn't fit into one of these three instances I've mentioned, just go to bed and sleep. You got absolutely nothing to worry about. But on the contrary, if having looked at it, the landlord served the notice after you've lived more than 4 months on the property, it was not owing you any prescribed fee, or is the case that there was no repair notice served on it and is giving you one, then you need to watch more, because there are things you can still do even without the need to consult a solicitor. So I'll tell you now. The first thing you need to look out for a landlord to issue a valid Section 21 notice, he must have given you EPC. EPC is the Energy Performance Certificate, which every property in England and Wales are by regulation required to have. They determine the energy quality, of every house. So here in England, at the time of rent or renting, your landlord must provide you with a copy of the EPC for the property. The other thing your landlord must do, if the house has got gas installation, he must provide you with gas safety certificate. Note where I said, if your house has got gas installation, not every house would have gas installation. So you have to decipher this for yourself. If you don't have gas installation, you've got absolutely nothing, to ask a landlord, for a gas certificate, for absolutely no business asking him for that. So EPC, gas certificate. And the other thing, in England and Wales, most local authorities have developed this regulation whereby landlords are required to take out licenses before they can rent. If you run an HMO, for instance, you must have the HMO license. And if it's a private dwelling, I must also have a private rented license. If your landlord at the time of renting the property to you does not have this license and is come now to issue you a Section 21 notice, absolutely nothing to worry about. And then the other thing is, you're required to pay deposit more often than not. When you pay this deposit, you're probably wondering, am I going to get my money back? Don't worry, you're going to get your money back. Because here in England and Wales, we have a scheme whereby money is collected as deposits are put into a dedicated scheme, for your protection, which means even if you rent the property for 10 years, the law is that your landlord must not touch that money, and he must protect that money. He must protect that money and provide you with a certificate of protection. The certificate will state your name, will state the scheme under which it has been deposited, and the fact that you can contact them to ask for your money back in the event that you have been evicted or you live in the property. So this certificate must have everything. And the law is that your landlord must protect your certificate upon receipt of it and provide you with a certificate of that protection. It's got prescribed information within a month of your tenancy. So even if your landlord protect your deposit and then fail to provide you with that certificate, he has still not complied with the provision of the law, and he cannot serve your Section 21 notice. The last but not the least, since 2015, there has been this thing called How to Rent Guide. The whole idea is to assist tenants to understand what their rights are, what their duties are with respect to any property they are taking, and if they have been evicted, what they can do, the resources available to them. So the law requires landlords since 2015 to provide tenants with the latest How to Rent Guide at the time of renting. So ask yourself, did I get a copy of this? Usually landlords will send it to you via email because it's quite copious, and I don't think anybody will make a copy of that. They send to you via email, send to you via WhatsApp, send you a link or something. So check to make sure you've received it. If you did not receive this, then your landlord has not complied. So let's do a run check. The first thing I said is the EPC. Second thing is the gas certificate. Third thing is the license. Fourth thing is the deposit, protection and providing you with a certificate. And the last thing is how to rent. If any of these things, is missing. If your landlord failed to comply with just one, he cannot serve you a valid Section 21 notice. You see, it's quite tough, isn't it? It's very tough for the landlord to do Section 21 notice, even though it's no fault, because he's got a lot of things to comply with. And the law intentionally put those things there. And you see, as we discuss, why this is important, because in the other Section 8, most of these things do not apply, you know. But again, like I said, I'll be explaining that to you. So those are the things you have to make sure you understand, and you ask yourself, did I get this? Did I get the EPC? Did I get the license? You know, did I get the certificate for the deposit? Did I receive out to rent guide? I mean, the property is properly insulated and it's called gas installation on it. Did I receive the gas safety certificate, the current one at the time of renting? If any of this thing is missing, like I said, then if you've received Section 21 notice, I'd rather you go back to bed, get under your duvet, forget about it. It's like nothing happened. Because if he proceeds to court on the basis of that Section 21 notice, you can ask the court to strike it out. And you're not just going to get it struck out, you're also going to be able to claim your cost for attending court on that day. And you know what? This happens many a time. And because of this, many landlords comes back to us and say, oh yeah, I'm having trouble, you know, getting my tenant out. I went there, served this notice, and this is what's happening. The court struck it out. It's because they've not done things properly. And then they come back to us, and then we then advise them on what to do. And guess what advice we give them? Section 8. So that brings us to Section 8. Section 8 is quite different from Section 21. Section 8 simply means that there must be a legal reason for a landlord to wanting his property back. If the landlord wants his property back, he must give you reason for wanting that property back. There are many reasons. It could be that he wants the property back because he wants it for himself. Or it could be that the mortgage has got a problem and the mortgage, the lender wants to sell the property. It could be anything. It could also be that you are in arrears. Yeah, in this case, you could be at fault. You know, you're allowed to be at fault. It's the reason why it's going to want the property back. It could also be a breach. Maybe you've committed a breach, you know, of the tenancy, and he just wants his property back. If any of these things, you know, happens, then the landlord can validly serve a Section 8 notice. So what's a Section 8 notice? A Section 8 notice, simply put, is that notice the landlord gives to you requesting his property back because you have committed one breach or the other, or for any other reason that's got nothing to do with breach. For instance, if he wants the property back for himself, or he wants the property back because he needs to redevelop, that's got nothing to do with you. It's not your fault. But again, there must be a legal reason, and he must back it up with evidence. You see? So that's a Section 8 notice. If he serves the Section 8 notice, what does that mean for you? A Section 8 notice means that you have to live within the notice period. The other thing about Section 8 notice is that the minimum notice is 2 weeks, as against Section 21, which is minimum 2 months. You know, I was going to say 60 days. Yeah, 2 months or 60 days. That's the minimum for that. But with this one, it's just 14 days. In 14 days, you have to vacate, which is why we prefer Section 8 as solicitors. We'll rather do it quickly, get to court, you know, get a tenant, you know, out of the property and all of that. But most landlords, because they want the easy way out, they don't want to have to attend court. They'll prefer Section 21 until they mess things up and they come to us. So yeah, so that's the thing with Section 8. So upon receipt of Section 8, what should you do? You don't have to panic. Same thing we said with Section 21. First, consult a solicitor if you can. If you can't consult a solicitor for one reason or the other, the one thing you have to think of is, oh, did I receive the correct amount of notice? You know, like I said the minimum notice is 2 weeks, but not for everything. There are certain breaches that require the landlord to give you at least 2 months. So the first thing you might want to check, oh, the landlord is giving this as reason, is giving me 2 weeks. Is that correct? You might have to consult maybe the Citizen Bureau or any solicitor firm, you know, that is close by to you if you can afford one. If you can't afford one, then you have to do extensive research online. You know, you have to sit online, keep looking at, you know, options available, and make sure you read the right thing, because if you read the wrong thing also, you might get all confused. My advice to people is, when you're looking for something that has to do with things of this nature online, it's best to look at information connected to government website. So if you see anything Gov UK, that's valid, and it's probably up to date. But if you check any other thing, it could be old information, they might not apply again, and people don't really update these things. So bear that in mind if you're researching on your own. Having said that, once you receive that Section 8, you look at that, you receive the correct amount of notice, then that's good. But if you haven't received the correct amount of notice, then you have a chance in court to ask the court to set it aside, And the same fate that would be for a landlord that has done things wrongly with Section 21 will happen to a landlord that has done things wrongly also with Section 8. And like I said, the court will also grant you cost, for wasting your time coming to court responding to it. You're entitled to your cost of the day. So that's how these things work. So you understanding this, it's very good. But like I said, my priority is for you to understand how to react when you receive these notices. Panicking won't save anything. But if you receive them and you can afford a solicitor, that's good. But this video is for people who can't afford solicitors. So the first thing you do those checks that we've talked about. Section 21, you do all the checks. Section 8 is just very few checks. Just make sure your name is correctly spelled, the property is correctly identified, and you've been given the right amount of notice and things like that. Once that is there, that's it. But once any of those things are lacking, there are reasons for you to then challenge this process in court. If you've been following this video, you will see there are quite a lot of differences between Section 8 and Section 21 notice. I know I talked quite a lot, so I'm going to summarize them for you. The first thing is, with Section 21, to no fault of yours, you've been asked to leave. So we call it the no fault eviction. But Section 8, there must be a legal reason for anybody to want you out. That's number one. You get that. Number two, with Section 8, you don't have to comply with anything. EPC, gas safety, license, deposit. Even if you collected deposit and you didn't protect it or give a certificate to the tenant, you can still use Section 8. So all that, cannot stop you. All those requirements will not stop you, as far as Section 8 is concerned, The other thing is Section 8 is a long process. Section 21 is the accelerated process. What does this mean? Accelerated to the extent that once you serve a Section 21 notice, what it simply means is that after that notice, if you put in a claim in court and your tenant does not file a defense within 14 days, you can ask the court in the comfort of your house for a possession order, meaning you don't have to attend court. So that's why we call it accelerated procedure. And this is why most landlords prefer this, mode of eviction, because with that, they don't then have to instruct solicitors. They can do it themselves, and they only come to us when things get messy. And then that's when we then advise them to do it using Section 8, because for us it's quicker. You give the minimum notice, you could be in court as soon as possible, get the tenant out. But the only reason landlord prefers Section 21 is because they can do it themselves and it saves them a lot of money. So, but for the other one, it's long-winded. Once you do Section 8, the tenant doesn't vacate within 14 days or whatever required notice period had been given, then you can then file a claim in court. The court will give you a hearing date. You must attend and prove to the court whether the tenant is there or not. Even if the tenant doesn't file a defense, you're not entitled to possession. You have to prove to the court why you should get possession. So that's the difference between Section 21 and Section 8. With respect to Section 8, again, Section 8 has a minimum notice period of 14 days for Section 21. I think I mentioned that whilst explaining. Section 21 must be minimum of 2 months or 60 days, so that's another difference between the two. And the last difference between them, this is a big technical. When you use Section 21, you can only ask for one thing, that's possession order. But when you use Section 8, you can ask for possession order and rent arrears. So if a landlord is using Section 21, what they tend to do more often than not, in cases where tenants owe them money, is they will use Section 21 and then evict the tenant and then commence money claim online to recover whatever rent arrears. But again, that's still, uh, I mean, it's time consuming doing all of those. It could take a year or more before they'll get the two results, that they desire. But if you instruct a solicitor or they use Section 8, if they know how to go about it and they've they've used their, Section 8, what they will get is that with that simple claim form, they can ask for their rent, which is in arrears, and also ask that the tenant vacate the premises. And the court, if the court is convinced, if the evidence are there, even on the first hearing, the court can grant this order. So these are the differences between a Section 8 and a Section 21 notice. Okay, I said earlier that we will talk about the renters reform bill. Uh, there's been a lot of noise about it, but again, for tenants, it will look like a law that has come to correct the injustice that has been permeating that sector for a long time. Like I said, Section 21 will allow your landlord to evict you without any reason. You could be the best tenant in the world. You could, like my Nigerian people would do, you could even greet the landlord morning, night, and evening. You could pay your rent, regularly. You could do everything that is required of you. And then still at the end of the term, or even before the end of the term, the landlord will come to you to say they want their property back. I've got good news for you. The Renters Reform Bill is going to come into law 1st of October this year. Right now, as a matter of fact, as we speak now, it's been debated at the House of Lords. The second reading is going on as we speak, and it's probably going to pass. It's passed the first reading since 1st of May. Second reading is going to be today. It goes into committee and report stage. Then it comes back for third reading, and that's the end of it. The timetable for all of this, we expect it to finish before summer. And then by late summer, August, it's going to receive the King's signature. We call it royal assent, and then it becomes law. What I can tell you about this law is that for new tenancy, starting after 1st of October 2024, you will enjoy the benefit, which means that no landlord can use Section 21 notice to evict you any longer. It's going to be Section 8, meaning they have to be in court, they have to prove possession, before the court will grant it. So you don't have to feel the way you feel right now with Section 21 for any longer. In less than 5-6 months, all that is going to be corrected. But for existing tenants, if your tenancy is existing by the time this law comes into effect, I'm afraid you have to wait at least another 1 year, because the implementation is in stages. For existing tenant, landlord can still serve you Section 21 notice until 1st of October 2025. So that's the only difference between it. So I hope that information is helpful. Having said that, I want to say thank you. I hope you've learned a thing or two. Again, I've spoken generally, so I might not have addressed your specific circumstances, but not to worry. All you have to do is to subscribe and send us an email or WhatsApp message. Our details are in the description below. Communicate with us, get this done. Once you do that, our team will be able to, correspond with you, and we'll take it from there. Remember, we've always said that if you're a subscriber, you're entitled to 10 minutes free legal advice, no obligation. So you can take advantage of that, but you have to be a subscriber. So until next time, I want to say thank you for listening. Stay blessed.